Hey everyone, welcome to this explainer. Today we're jumping right into a really fascinating intersection of law, religion, and property. We're going to look at Islamic personal law and how exactly it interacts with civil property structures. Now, if you've ever wondered how the legal system handles an asset when the ultimate owner is considered to be, well, God, you're in the right place. We're going to unpack the mechanics of Islamic endowments, which are known as the Wakif, and see exactly how they stack up against a standard legal trust. Okay, let's dive into this. This brief little quote here perfectly captures both the legal and philosophical essence of the Islamic Waqf. Tie up the substance and give away the fruit. It's kind of elegant, right? Basically, it means you're locking away the core asset so it can literally never be touched, but you're continuously harvesting the benefits of it to give away to others. So here's our roadmap for this explainer. We'll be hitting four main points: defining the Islamic Waqf, the role of mutawali, Waqf versus standard trust, and finally, the Prizet Waqf clash.
All right, let's get into Section 1, defining the Islamic Waqf.
Now, before we can really compare this to anything else, we have to understand its unique DNA. The actual word waqf comes from the Arabic root verb waqafa, and that literally translates to stop, to hold, or to keep. So when a property is dedicated as a waqf, the underlying property, the corpus in legal terms, is stopped from passing into the hands of a third person. Legally speaking, ownership vests directly in God. The property just remains entirely intact, kind of like a deeply rooted plant, while only its blooming benefits, the usufruct, are harvested and given away to charity.
To make this even clearer, the legal scholar Fizzi outlined three absolute essentials of a waqf. First up, the motive must be strictly religious, pious, or charitable within Islam. So a merely secular motive? That would just make it a standard gift or trust, not a waqf. Like, a court actually ruled you can't create a waqf to support a place of worship for a religion other than Islam. Makes sense, right? Second, it has to be a permanent endowment. We're talking an unlimited period here. And third, the benefits must be utilized for the good of mankind. Because of all of this, once a valid waqf is formed, it becomes completely perpetual, irrevocable, and the property is permanently inalienable. You can't undo it.
Moving right along, Section 2, the role of mutawali. So we've just established that the property essentially belongs to God, which, raises a pretty incredibly practical question. Think about that for a second. If an asset is divinely owned and permanently locked away from earthly transfer, who actually manages the day-to-day operations? Who's fixing the roof or, collecting the rent? Well, that earthly responsibility has to fall to a manager, and that manager is called the mutawali. If we were writing out a job description for this role, here's exactly who can apply. First and foremost, anyone appointed has to be of sound mind and have attained the age of majority. They also have to actually be capable of performing the required functions of that specific waqf. Now, interestingly enough, under the Privy Council ruling in the Shahar Bano versus Aga Muhammad case, there's actually no legal restriction against a woman becoming a mutawali, as long as the duties don't involve specific religious activities. There is a geographical restriction, though. A foreigner cannot be appointed as a trustee of a property in India. So the absolutely crucial point here is this. The mutawali is merely a superintendent or a manager. They are emphatically not the owner. Because they're just managing the usufruct, those benefits we talked about, their powers are incredibly limited. A mutawali is strictly barred from selling, exchanging, or mortgaging the waqf property. They can't even incur a debt against the property without proving extreme urgency and getting prior explicit sanction from the court. And since their role is purely administrative, they can absolutely lose their job if they misbehave. A mutawali can be removed by the court for things like insolvency, intentional property damage, or misfeasance. To give you an idea, in one landmark Supreme Court case, it was held that a mutawali using waqf money to buy property in his wife's name was a massive breach of trust and definitely sufficient grounds for removal. They can also be removed by the Waqf Board under the 1995 Act, or even by the Waqif, who is the founder of the endowment. The founder actually retains the right to remove the mutawali even if they didn't explicitly write that right into the original waqf deed. Which brings us to Section 3, Waqf versus standard trust. Now that we've got a solid grip on the mechanics of a waqf, we arrive at the core comparative showdown of this explainer. When we put these two structures side by side, the legal differences are pretty stark. Let's look closely at permanency, revocability, and beneficiary rights. For purpose, a waqf is strictly restricted to religious or charitable objects recognized in Islam, whereas a standard trust, that can be created for literally any lawful object. Looking at beneficiary rights, in a standard trust, the founder can happily just make themselves a beneficiary.
But in a Wakf, with the exception of Hanafi law, the founder cannot reserve benefits for themselves. And finally, lifespan. A Wakf is entirely perpetual and irrevocable. Once it's done, it is done forever. A standard trust, on the other hand, doesn't need to be perpetual and can be revoked under certain conditions.
Now, what's really interesting is how this difference extends to the managers, too. As we just saw, the mutawalli's powers are highly restricted when it comes to selling or mortgaging the property. But a standard trustee generally enjoys much broader administrative powers to manage, sell, or invest the trust's assets, as outlined in the trust deed. It's actually a really important point to note here that Muslims are absolutely allowed to use the Indian Trust Act. If a Muslim individual wants to settle their property with all the flexibility, revocability, and broader manager powers of a standard trust, they can absolutely choose to do so under the Act instead of creating a waqfa under Muslim personal law. All right, our final section, Section 4, the private waqf clash. So what happens when these two completely different legal philosophies collide in a courtroom? Well, to understand this clash, we really need to define a specific type of private waqf, known as waqf al-awlad. This is essentially a family settlement, where the owner decides the corpus of the property will remain permanently inalienable, but the entire benefit will go to their own family and descendants down through the generations. It's only when the family line entirely dies out that the ultimate benefit finally reverts to the poor. Let's see how this builds, because this specific structure sparked a massive 19th century legal controversy. English judges, who were deeply steeped in standard trust law, where you simply can't tie up property in perpetuity just to benefit your own family, looked at these private waqfs with deep, deep suspicion. To them, the charity part looked like an illusion, potentially delayed for hundreds of years. So the Privy Council actually began invalidating these family waqfs in major cases, stating they infringed on rules against perpetuity. Well, as you can imagine, this sparked widespread outrage in the Muslim community. Scholars like Allama Shibli Numani pushed back hard. They argued that in Islamic jurisprudence, charity isn't just restricted to strangers. Providing for your own children and descendants is also considered a very valid act of charity. This intense pushback eventually forced the legislature to get involved. And in 1913, the Musliman Waqf Validating Act was passed, which officially made these family waqfs lawful. It really is a fascinating journey from ancient religious texts to modern civil courtrooms. We've seen how the Waqf stops the transfer of property, vests it beyond earthly ownership, and heavily limits the earthly manager, all of which is in stark contrast to the flexibility of a standard civil trust. Which leaves us with a final thought to ponder as we wrap up this explainer. When the unstoppable force of divine permanence meets the immovable object of civil property law, which system truly holds the power over the property? Thank you so much for joining me for this analysis, and keep asking those great questions.